Well, I just want to welcome everyone here to the Eastside Freedom Library. I'm Peter, the co-founder, and here is Beth, the other co-founder, and then our collaborator Carla is Facebook live streaming this. And so I like to tell people, if you're in the witness protection program, make sure to hide your faces. And then Sydney is going to be taking pictures and posting them on Instagram. So we're really into social media, whatever that means here. And social change, absolutely. You know, this is a Carnegie Library building. We like to remind people that immigrant iron miners and steel workers and coal miners made Andrew Carnegie rich, and we should thank them for a beautiful building like this. So I was excited when my old friend David said that they would like to create and perform this piece marking the 50th anniversary of the contempt treatment of Bobby Seale in the Chicago conspiracy trial. So for a historian like me, anniversaries are great. Give us reasons to talk about this. And so tonight we're not just going to talk about it, but we're going to be drawn into it through the medium of music. So I'm going to turn things over to David and get out of the way.
Thanks, Peter. Thanks everyone for coming. I ran into this this album of a transcript. It's a performance by actors acting out the transcript of the portion of the trial that dealt with the contempt citations, and the day, November 5th, 1969, would be the proceedings under which Bobby Seale was officially charged with, it came to like 22 counts of contempt. He was sentenced, and his trial was separated from the other 7 and postponed for later in 1970. And all of this was happening while I was off sabbatical in Vietnam. I call it my full Westmoreland fellowship. That in spite of being completely out of the world, as we called it, most of us who were draftees and understood what was going on politically back then, understood that that trial was going on, and it was an important trial. And you know, as a composer, I think anniversaries have a certain ring to them as well. And to be able to work with Homer Lambert and Randall Davidson, 2 friends that I met when I first came up here in the late 70s from Illinois, is just really a treat. So we're happy to present our musical response to these proceedings for you tonight. And hope that you enjoy it. Thanks again for coming.
It is 2:25 p.m. Central Standard Time, November 5th, 1969. We are standing on the steps of a federal building in the Chicago Loop. Inside is the United States District Court for the Northern District of Illinois. There, for the past 6 weeks, 8 men, who have been evidently become known as the Chicago Eight, have been on trial, charged with conspiracy to cross a state line to incite to riot, and also with a separate crime, having those same intentions as individuals. The 8 defendants include veteran pacifist leader David Dellinger. The government actually calls the case the United States versus David Dellinger and others. The others being Yippies Jerry Rubin and Abby Hoffman, youth and peace activists Tom Hayden and Rennie Davis, college professor John Thorns, and community organizer Lee Winder, all white and all free on bail. And finally, Black Panther Party Chairman Bobby Seale, who is held in jail without bail since he is also charged with first-degree murder in Connecticut. In the past 6 weeks, the government has been presenting its case against all the defendants. But another issue, which looks as though it may come to an explosive head this afternoon, has almost overshadowed the government's presentation. We've got to move along to the courtroom now. Each of these 4 doors to the lobby is guarded by 6 armed marshals. We will have to identify ourselves.
May I see your briefcase?
We can move along now through the lobby to this bank of elevators. There's cartoonist Jules Pfeiffer. Since neither television nor still cameras are allowed in the courtroom, the magazine has commissioned him to sketch his impressions. There's Tom Wicker, covering for the New York Times, journalists from all over the world.
This elevator, please.
We're on our way to the 23rd floor.
What's Judge Hutton going to do? My hunch is he's going to sentence you for contempt and see if he can separate it from the trial. After 6 weeks.
Judge Hoffman's court is 2 stories high. When we enter it, through those swinging doors up ahead, we will be in an aisle between 2 rows of wooden benches. Your purse, please. Spectators are searched again before being seated on the left. On our right, the press, and behind them, friends of the defendants. Let us take our seats. As you see, in the large open space in front of the chair are the defendants, at 4 tables arranged in a large rectangle. At the far end are their attorneys, William Kunstler and Leonard Weinglass. Opposite this group is the prosecution table, Thomas Ferran, Richard Schultz, a junior attorney, and an FBI agent who assists them. Behind them is the jury, where 6 to 12 jurors and 2 alternates, all but 2 of them women. We're probably about to start. Judge Hoffman is already more than 20 minutes late. This bench is elevated well above the court. Behind it are pictures of George Washington, Benjamin Franklin, and Abraham Lincoln. And above them, the great seal of the United States. Through the door which leads to the lockup, Defendant Seale is now being brought into court.
All rise. United States District Court for the Northern District of Illinois is now in session. The Honorable Julius Hoffman presiding.
It is now 2:35 p.m. The jury has not been called in. 22 marshals are guarding the entrances to the court. They are all armed. Several are standing near the defendant's table.
There is a matter I wish to take up, gentlemen, before we proceed further with this trial. I think, Mr. Witness, that you may be excused and go into the witness room.
Apparently, from the whispering all around us, what we have all assumed is true. This afternoon's business is with Bobby Seale. As you know, Seale had asked before the trial started that it be postponed until his attorney, Charles R. Gary of San Francisco, would be sufficiently recovered from a gallbladder operation to appear for him. Gary himself appeared before Judge Hoffman to request the delay, which would have only been for a few weeks. It was refused. September 12th, Seale was taken from jail in San Francisco by federal marshals. They chained him to 2 other prisoners and drove him by a very roundabout way to Chicago. In fact, they took 6 days to get him there, and only lodged him in Cook County Jail September 18th. Concerned for Seale's safety and eager in Charles Gary's absence to consult with him, Attorney Kunstler filed an appearance on Seale's behalf with the court. This was required if he was to have the right to see Seale. This filing has ever since been the basis for the court's claim that Seale has an attorney, namely Kunstler. On September 26th, the day the trial began, Seale discharged Kunstler for the record and said he would exercise his right to represent himself. The judge refused to accept this and refused to admit when Kunstler tried to lodge a withdrawal a few days later. Hoffman has maintained to this day and this hour his insistence that Kunstler is Seale's attorney, though Seale says he is not. Kunstler says he is not, and Kunstler and Seale have not consulted together since the trial began. Most of the occasions on which Seale has interrupted the proceedings in the past 6 weeks have been efforts on his part to assert his right of self-defense, including attempts to interrogate prosecution witnesses as his attorney would have done. The right of self-defense is guaranteed under the Constitution as well as by statute, and has often been exercised, especially by defendants who feel that they're on trial for their political views, and who want not only to defend themselves, but to use the court, insofar as rules of procedure allow, as a political forum. Judges are required to grant this right, provided it is requested early enough in the trial. The witness has left. The defendants, including Bobby Seale, are in place. The courtroom quiet. Now, Judge Hoffman is about to begin.
As I think everyone who has attended the various sessions of this trial must, if he is fair, understand. This court has done its best to prevent or to have repeated efforts to delay and obstruct this trial, which I think have been made for the purpose of causing such disorder and confusion as would prevent a verdict by the jury on the issues presented by the indictment and on the pleas of not guilty thereto. I must finally steps to ensure that the trial, as it continues, be conducted in an atmosphere of dignity. That the defendants, each of them, are entitled to have prevailed in the trial of this outcome. So we all know the defendant Bobby G. Seale has his conduct in evidence of this court during his which has not only contumacious in character, but the misconduct was of so great a character as to disrupt the operation of justice. We have in the courts the Federal Rules of Criminal Procedure, which, together with Title 18 of the United States Code, represent the rules that the court must interpret and apply in the trial of criminal cases. And in conformity with the Rule 42A of the Federal Rules of Criminal Procedure and Title 18, United States Code, Section 401, I certify at this time that I saw and overheard the conduct of the defendant, Bobby G. which I refer during these observations, which conduct took place in the actual presence of the court during the trial of this case, which is entitled United States of America versus David Dellinger and others, the case number being 69CR180. The trial commenced on September 24, 1969, and has continued through this morning. I learned not only from seeing and hearing the conduct to which I'm about to refer, the conduct of the defendant Seale, but from reading the transcript of the proceedings, that the acts, statements, and conduct of the defendant Seale, which I shall specify here, each constituted a separate contempt of this court, and that each constituted a deliberate and a willful attack upon the administration of justice.
That's a lie.
An attempt to sabotage the functioning of the federal judicial system.
That's a lie. I spoke on behalf of myself. I spoke on behalf of my rights and to make motions and requests.
I don't permit to speak while
I stood up and I wore all the lectern and demonstrated the fact that I wanted to cross-examine the witness. The black men here in town hate me to go all the way to California. My lord indicated that I tried to persuade you again to recognize it. I was no more 5 minutes, and you're talking about distorting the proceedings of the trial. That's a lie. No, it's a lie.
It's been very difficult for me, Mr. Seale.
It's been very difficult for me, Judge.
I tried not to. I have done my best. I have done my best.
I don't stand up and speak in my own behalf. I do, and you know.
You know you have a right.
I have a right to speak. I have the right to speak and make requests and make arguments and to demonstrate the fact that I want to cross-examine. When you say I disrupt, I have never tried to fight anybody. I've never tried to hit anybody. You know it now. And in my mind, my emotions, I'm fascist and I'm petty. And then I can give you my arguments, my emotions will all walk that as long as my constitutional emotions.
I find, I repeat, that the act, statement, and conduct of the defendant Seale, to which I shall refer specifically, each constituted a separate contempt of this court. That each constituted a deliberate and a willful to sabotage the functioning of the federal judiciary system. That this misconduct was of so grave the orderly administration of justice. To maintain the dignity of the court and to preserve order in the courtroom under these circumstances has been a task of utmost difficulty. There were, accordingly, as the record shows clearly, repeated warnings and admonitions to the seal to cease this conduct. And there were warnings that it would be dealt with at an appropriate time. This continued disruptive conduct necessary for the court. For the first time, physically and emotionally restrained him. They proved insufficient because of the ill effect that the continuation of the activities might have had in the future on the administration of justice. In this case, I find it is necessary that I have tried to make it clear to the that his conduct is gracious, but in persuading him to so conduct himself as we expect individuals to conduct themselves in the courts of the federal system. As isolated excerpts from or references to the transcript can give but a partial of the acts, statements, and conduct to which I refer, I make the entire record part of these proceedings. The entire reading of this record cannot and does not reflect the true intensity and the extent of the disruption which, in some instances, were accompanied by chaotical which occurred in
A week ago, Seale addressed a couple of matters in the Spanish election. We, the press, heard him tell them to remain cool, but defend themselves if attacked by marshals. When Judge Hoffman entered the court a few minutes later, Assistant U.S. Attorney reported this to him as an attack on the court. Seale objected to this interpretation, but in vain.
Accordingly,
I don't stand up in any court in America and say,
accordingly, I object to the defendant Bobby Seale guilty of several criminal contempts to which I was Instead, in these specific acts and statements of the defendant Seale as contemptuous, the court has selected only the most flagrant ones. On Friday, September 26, 1869, during the motion session prior to the opening statement, the defendant dismissed the court in the following manner.
I have constantly denied this right of legal defense of counsel of my choice who is affected by the judge of this court. And I can only see the judge as a blatant of the United States
Just a minute.
with gross prejudicial error towards all defendants and myself.
Just a minute. What did you say?
I said if my constitutional rights are denied, as my constitutional rights have been denied in the past, in the course of this, etc., there's an act of there's going to be a prejudice against even defendants are telling the judge.
That is item 1. Number 2. During the morning session on October 14, 1969, while the court, Assistant United States Attorney Schultz, Defense Counsel Mr. Weinglass were engaged in a colloquy, the defendant Seale interrupted Mr. Weinglass the following.
Hey, you don't speak for me. I would like to speak on behalf of my own self and have my own counsel handle my case in behalf of myself. And how come I can't speak on behalf of myself? I'm my own legal counsel. I don't want the employers to represent me.
I'm a lawyer of record, and he has been of record here. September 24.
I have been arguing that before the jury heard one shred of evidence. I don't want these lawyers. I don't get a legal defense. My father is Charles Garrett.
I direct you, sir, to remain quiet.
And the original
Remain quiet.
I want to defend myself. Do you mind, please?
Seale continued to speak after the court seemingly requested him remain quiet. Item number 3. During the morning session of October 16, 1969, out of the presence of the jury, while the witness Oklahoma was testifying, a colloquy began between a marshal and some consular. The marshal explained that 3 spectators who were not at the court had been allowed to return. The defendant Seale stated to the court, quote, "I think there is a bit of racism involved."
They were black spectators. When defense attorney Kunstler objected to their ouster, they were readmitted. The marshal said he thought one of them had been sleeping. Item number 4. During the afternoon session on October 20th, 1969, 1969, out of the presence of the jury, the defendant Seale presented and extensively argued a motion to be permitted to defend himself. At the conclusion of the argument, the jury returned to the courtroom and the following.
I would like to say, Judge, that you have denied my motions to defend myself, and you know that the jury is prejudiced against me.
I will ask you to sit down.
You know that the jury can't go home to loved ones at their home, and you know that they have been prejudiced against me.
Ladies and gentlemen of the jury, you are excused.
The trial of the jurors had received threatening letters signed. These letters were then turned over to the judge, who showed one of them to the first of the judgment and asked to continue to keep. She said that she should not the judge had shown demonstrated her abscess and delivered it immediately to the FBI. The second jury was not bothered by the letter, but nevertheless, the entire jury has been locked up for the rest of the trial, or the rest of the lock.
They have been made prejudice against me, I know. I should be allowed to defend myself. I should be allowed to speak so I can defend myself. Be quiet. Don't tell me to shut up. I need time to defend myself.
Mr. Seale, I must admonish you that any outbursts such as you have just indulged in will be appropriately dealt with at the right time during this trial, and order you not to do it again.
In other words, Judge,
and if you do it at your own risk, sir.
In other words, you're saying you're going to put me in contempt of speaking on behalf of myself.
I will not persecute you.
Is that what you're saying to me? I mean, clear.
I want you to be quiet. That is all. You have a lawyer to speak for you.
They don't speak for me. I want to represent myself. Jail and everything else. And now you're saying you're going to put me in the jail. But you're going to put me in contempt of court. Speak on behalf of myself. Because I'm speaking on behalf of myself. Jury is prejudiced in the sense you know for threatening letters, so-called threatening letters you fly. I can't possibly clear that. I will speak. They can't speak on behalf of myself. I still want to defend myself. I know I have a right. I just want to let him know that racist, that fascist. You know the black man trying to get a fair trial in this country. The United States government, Nixon and the rest of them. Go ahead and continue. I'll just sit back here and watch it get railroaded.
If the court believes there is one thing that has not been placed on the record, the fact that since the trial began, in fact, I think since September 24, as far as I know, and I think this is 100% accurate, given the defendant that with Mr. Seale and the lawyers, the marshals have made arrangements to bring them to a room where all of them could get together. Seale and the defendants and the lawyers have all met and consulted on every occasion that they have so requested. It has been done on a regular basis since the trial did begin. I just thought that should be on the record. If there is any statement by defense counsel to the contrary, since I'm not at the meetings and I don't know how many times they've asked the marshals to meet, I think they should so state now.
I would like to put something on the record. You know you're in that room unless you got a tape in there. I am asking you to keep that man is lying on me. I with these debates and argue with these so-called cats about so-called defending me. I want that.
During the morning session on October 22nd, 1969, while argument on a motion of Attorney William Kunstler for leave to withdraw counsel for the defendants following the third in open court.
Can I speak on that and answer his evidence?
No, this is not your motion, sir. Your motion has been decided.
Because I can't speak in behalf of myself.
Not at this time, sir.
Why not?
This is your lawyer's motion.
That ain't my lawyer.
This is not your motion. This is the motion for Mr. William Kunstler for leave to withdraw as your lawyer.
Well, this man has misconstrued a whole lot of things concerning my rights to defend myself, and he knows I do. They can't attack you up and sit up there and say rotten, crazy stuff. Rights to defend myself.
I would request the marshal ask the young man to sit down.
I want my right to defend myself. And this man knew. I indicated to him he was not my counsel at the very beginning when I first got here and arrived and was put in jail.
That motion, since Since you will not listen to the case, sit down. Nothing, Mr. Marshall.
I still want my election and my railroad operation. You know it. From Nixon on down. I'm running around here fighting my constitutional rights.
Item number 6. During the motion on October 20, 1969, in the presence of the jury, prosecuting attorney Schultz is speaking.
Your Honor, before the next witness testifies, I think if the court would permit the government, well, we haven't offered the picture as a matter of fact. A boy with a black power symbol and a sweatshirt that was identified by Officer Tobin and Carcerano at the That's the one. We're going to move to an evidence I'll charge to the counsel.
That is somebody correct the court on that. That is not the black power sign. It's power to the people.
The Marshal will stop the talking, please.
Yes, but it's still wrong, Judge Hoffman. It is not the black power sign. It is power to the people sign. And he is deliberately distorting that. And that is a racist technique.
If the court please, this man has been a racist.
Yes, you are. You are, Dick Schultz.
And call Mr. Foran a racist.
Ladies and gentlemen of the jury, I ask you to leave the court. Mr. Marshal, remove the ladies and gentlemen of the jury.
The following proceedings were held in the court, out of the presence and hearing of the jury.
Mr. Seale and Mr. Counselor, your lawyer, I must admonish you that such outbursts are considered by the court to be contemptuous, contumacious, and will be dealt with appropriately in the future.
Your Honor, the defendant was trying to defend himself, and I have already indicated
not defending himself.
I was, too, defending myself. Anytime someone gives me the wrong symbol in this courtroom, he is deliberately
not addressing me with authority,
distorting and putting it on the record. I want to defend myself against this lie. He's going to put that line crap on the record. No, sorry. I'm not going to sit here and get that. I'm not going to excuse his piece. I'm going to let you know that this man is erroneously representing symbols directly related to the party which I am chairman.
In the afternoon session of October 22nd, 1969, the court informed the defendant Seale that the court would supervise the
They don't take orders from judges, but I can convey the orders for them and they will follow them.
Seale is referring to a group of Panthers and instructed himself.
You may expect to be punished for it. I warn you right through this trial, and I warn you again, sir. Bring in the jury.
We protest our rights for 400 years. I mean, we've been shot, killed, murdered, brutalized, oppressed for 400 years.
There is another instance. That outburst may appear on record, and it does. Did you get it?
Yes, sir. I hope you got my part for the record, too, concerning that. Did you get that?
Yes, sir. And that outburst, too?
I think you should understand that we support Bobby Seale. At least I do.
That was defendant David Dell.
I haven't asked you for any advice, sir.
If you let me defend myself, you instruct me on the proceedings that I can act. But all I have to do...
You will have to be quiet.
All I have to do is clear the record. I want to defend myself on behalf of my constitutional
right. Defendant Seale has seeking to silent quiet for the acronym in the direction.
And the record shows that Bobby Seale speaks out on behalf of his constitutional rights. His rights to defend himself, his rights to speak on behalf of his constitutional rights in this court.
And again, let the record show that he has disobeyed the order of the court. Bring in the jury.
Please do.
At the opening of the morning session on October 27th, 1969, the following occurred in open court.
Ladies and gentlemen of the jury, good morning.
Jury. As I said it once, don't blame me for anything.
Mr. Marshal, will you tell that man to sit down?
Take a seat, Mr. Seale.
Mr. Marshal, I think Mr. Seale is saying something there.
I know I'm saying something. You know I'm getting ready to speak out on behalf of my constitutional rights again, don't you?
I will ask you to sit down, sir.
Sit down. You also know that I'm speaking out for the right to defend myself again, don't you? Because I have a right as a defendant, don't I?
I will have to ask you to sit down, sir.
You know what I'm going to say, don't you?
No, I don't.
Well, I've said it before.
I don't know what you're going to say, and you have a very competent lawyer of record here.
He is not my lawyer. You know I fired him before the jury was even picked and put together.
We'll ask him to sit down, Mr. Marshal.
Sit down, Mr. Seale. And what about my constitutional rights to defend myself and have my own
constitutional...
You have been denying them. You have been denying them. Every other word you said is denied, denied, denied. this country. What you're beginning to do. You're beginning to do. Mr. Seale, why don't you just try knocking me in the mouth?
Sit down, ladies and gentlemen of the jury. I regret I will have to excuse you.
Hey, I hope that you don't blame me for anything. Those false lots of notes and letters and that when you know it's a lie. The government did it to take that jury against me.
The following proceedings were had in open court out of the presence and hearing of the jury.
You got that? The administrative government with its Superman notions and comic book politics. We're here to the fact that Superman never saved no black people.
I might say, Your Honor, you that I have tried to withdraw from this, and you know that Mr. Steele...
What you've tried to do, Mr. Counselor. I know that your appearance is of record, and I know I have your assurance orally of record that you represent this man.
You have a withdrawal of that assurance, Your Honor. You knew that on September 30th. You knew that Mr. Seale had discharged.
You represent him, and the record shows it.
Your Honor, we can't go semantics. This man wants to defend himself.
This isn't semantics. I'm not fooled by all this business.
I still demand the right to defend myself. You're not fooled. After you've walked over people's constitutional rights, sit down. After you have walked over people's constitutional rights, the 6th Amendment, the 5th Amendment, the holiness and the groundless of this very trial, where people have the right to speak out, freedom of speech, freedom of assembly, etc. And you did everything you could with those dry, blind witnesses up there, presented by those agents of the government to lie and say and condone rotten, racist, fascist, by racist and people over the head. Not the
I shall bring out jury, please.
Item number 9. During the direct examination of the witness, William Front-Porch, 27th, 1769, the
I object to that because my lawyer is not here. I have been denied my rights to defend myself in this courtroom, and I object to this man's testimony against me because I have not been allowed my constitutional rights.
I repeat to you, sir, that you have a lawyer. Your lawyer is Mr. Counselor, who represented to the court that he represents you.
He does not represent
He
me.
has filed an appointment. Gentlemen, I will excuse you.
I have withdrawn or attempted to withdraw.
The defense held the motion before the jury heard any evidence, and I object to that
The
testimony.
information, sir, I do know. These two are not represented by lawyers. You are represented by a lawyer.
I am not represented by a lawyer. I am not represented here by Charles Gary. We should sit down, Mr. Seale.
Just keep on.
Keep on what? Keep on what?
Sit down.
Keep on what? Keep on getting denied my constitutional rights? I object to that. I check that license up here, testifying against me and the constitutional rights. It's not the lawyer's hands here. No, I object because you know just my rights to defend me. Except for other people don't have much money, but we've got that. And we big money, good money, and we know how to come over the I'm not gonna be tried. So I'm gonna talk on behalf of my constitutional rights and behalf of myself that my constitutional rights I'm able to defend my constitutional rights. I still object to that man's testifying because of my lawyer being here. Without me, the right to defend my people ain't supposed to have minds. That's what you think. But we've got bodies and we've got a mind. And you lose yours and your Superman syndrome. Comic book stories. You know, you must have to deny us our constitutional rights. You got it all.
The following proceedings were had in open court, within the presence and hearing of the jury.
Take that jury against me. Send letters that I know it's a lie. You put them in their homes and then they blame me every time I go into this room. They make me break their homes and you did it.
Are you going to
I'm gonna talk in behalf of your rights. Have to be right.
the direct examination of this witness, and I know, Mr. Seale, that your counsel has remained quiet during your dissertation.
You know what? I have no counsel here. I mean, I fired before the jury heard anything, and you know it.
That jury hasn't heard all the motions you denied behind the scenes. How you tricked that juror out of the stand there with that threatening me with that letter. But you know, that's your business. And then every time they be guns and they blame me every time. And never still, then you know.
Please continue with the draft.
This is item number. On October 28th of 1969, during the afternoon, while the witness William Theatrical was testifying on trial examination, the following
Mr. Wineglass, do you want to cross-examine this witness?
I would like to request to cross-examine this witness.
You have a lawyer here.
This man is not a lawyer. This man states against me. Furthermore, he violated Title 1892 of the United States, where you're still violating.
Seale is referring to Title 42, U.S. Code Section 1981, which cites a Reconstruction Era statute which granted black men equal protection under the law. He had the numbers.
Sit down, Mr.
You violated the code. You violated the United States law against my rights.
The Marshal will ask Mr. Seale to sit down in his chair.
You are violating Title 42, the United States Criminal Code. You are violating it because it states that a black man cannot be discriminated against in the state of
Will you sit down, Mr. Seale?
And you won't recognize it. So I would like to witness.
Will you sit down, sir?
I still
Well, you may not. May I remove the jury, please?
Ladies and gentlemen of the jury, you may be excused.
After the jury was excused, the defendant Seale continued to refuse to order of the court to remain silent. Thereupon the following occurred.
The records show that
Let the record show you violated that. A black man cannot be discriminated against in relation to legal defense. And that is exactly what you have done. You have, you know. Let the record show that.
The record shows exactly to the contrary.
Let the record show that you are violating, that you violated my constitutional rights. I want to cross-examine the witness. I want to cross-examine the witness.
Bring in the jury, Mr. Marshal, and we will let them go for the I admonish you, sir, that you have a lot of contemptuous conduct.
You are in contempt of the people's constitutional rights. You are in contempt of the constitutional rights of the masses of people of the United States. You are the one in contempt of the people's constitutional rights. I am in contempt of nothing. You are the one who is in contempt. The people of America need to admonish you and the administration. Let me examine the witness. You won't even let me read. You won't let me read my statements this morning. My motions this morning, that I want to no transcript for my defense.
Bring in the jury. Is he in the jury?
Yes, Your Honor.
Tell him just to bring him before the box.
I want to cross-examine the witness. Let the record show that the judge was laughing. Yes, he is
Who
laughing.
made that remark?
The defendant Hayden, Your Honor, made the remark.
And me.
Let the record show that...
I still want to cross-examine the witness to defend myself.
The jury was then returned to the courtroom to be excused for the day, during which time the defendant Seale continued to speak. Thereafter, the following occurred in open court.
You may sit down. I must admonish the defendant and his counsel.
Counsel ain't got nothing to do with it. No counsel.
You're not doing very well for yourself.
Yes, that's because you violated my constitutional rights, Judge Hoffman. That's because you violated them overtly, deliberately, in a very racist manner. Somebody ought to point to you the law to you. And you don't want to investigate it the people's constitutional rights. Black men died in the Civil War for their right of right. That right was made during the Reconstruction period. They fought 68,000 of them died. That law was made for me to have my constitutional rights.
Listen to me for a moment.
Why should I continue to listen to you unless you're going to give me my constitutional rights and let me defend myself?
I am warning you, sir, that the law...
Instead of warning me, why don't you warn me that I've got a right to defend myself?
I am warning you that a court has a right to gag. Now, I don't want to... Under the law, you may be gagged and chained to your chair.
Gagged? I'm being railroaded already.
The court has that right.
The court has no right whatsoever. No right to stop me. We have my constitutional right. Because the right to speak out on behalf of my legal defense.
The court will be recessing tomorrow morning at 10 o'clock.
Everyone will please rise. I am not rising. He's rising until he recognizes my constitutional rights. I should he's not recognizing my constitutional rights.
Mr. Marshall.
This is the 11th item of contempt Judge Hoffman has cited.
If the court please, before you came into this courtroom, if the court please, Bobby Seale stood up and addressed this group of Panthers.
That's right.
And Bobby Seale said that if he
I
is...
spoke out on behalf of my constitutional rights. I have a right to speak on behalf of my constitutional rights.
And call please, it's on again. Call please, keep this on the record. It happened this morning. That if he's attacked, they know what to do. He was talking to these people about an attack by them.
I told him to defend himself. You're rotten, pig. That's what you are. Yeah, you are rotten liar. I am a fascist pig. They have a right to defend themselves if they are attacked. And I hope that the record carries that. And I hope that the record shows that Tricky Dicky Schultz here is working for the Richard Nixon administration. And they all understand that Tricky Dicky Schultz is a liar. And we have a right to defend ourselves. And I will defend myself.
I clear the courtroom in the event that occurs again. Clear the courtroom of spectators if that occurs again. The record shows loud laughter among the spectators.
If the court please, that is what he said just as repeated.
Darn right.
In terms of a physical attack by the people in this...
Physical attack by those damn marshals, and if there's right, anything they have a reason to go to,
shrieking and pounding on the table and shouting. That will be dealt with appropriately at some time in the future.
If a witness is on the stand and testifies against me, I stand up and speak out on behalf of my right to have my lawyers and defend myself, and you deny me that. I have a right to make those requests. I have a right to make those demands on my constitutional rights. I have a constitutional right to speak. If you try to suppress my constitutional right to speak out on behalf of my constitutional rights, then I can only see you as a bigot and a racist and a fascist. I have said it before and I clearly indicated on the record. Let us go, nigga, yes.
Item number 12. On October 29, 1969, during the witness the cross-examination of the case before it was completed, the following occurred.
We read your record examination.
For the next book, I'd be able to cross-examine the witnesses. My lawyer's not here, and I think I have the right to defend myself in this court.
I'll take the jury out and then we go to lunch with the usual order.
You have George Washington and Benjamin Franklin sitting in a picture behind you, and they were slave owners. That's what they were. And they were slave owners, and you were acting in the same manner by denying me my constitutional right to be able to cross-examine criminals. You have examination. My other defendants, the lawyers, and we never come across examining.
Mr. Seale, I have admonished you previously.
I have a right to cross-examine.
Promise you what might happen to you.
I have a right to cross-examine witnesses.
Mr. Kunstler has his appearance on record. Here is your attorney.
He is not my lawyer. You have forced us both to make your
young man, and if you keep this
old man, if you keep up denying my constitutional right to expose to the public and the world that you do not have people's constitutional rights to defend themselves.
Well, tell you that on the internet yesterday,
Gee, what can happen to me more than what Benjamin Franklin and George Washington did? What can happen to me more than that?
And I might add that since it's been said here that all of the defendants support you in your position, I might conclude that they are bad risks for bail. I say that to you, Mr. Contempt. If you can't control your mind,
I still demand my constitutional right as a defendant in this case to defend myself. I demand the right to be able to cross-examine him. He has the and I want
believes that while the marshals were seeing Bobby Seale beating him in the chair, the defendant Dellinger physically attempted to interfere with the marshals by pushing them out of the way.
I want my right to defend myself.
Mr. Kessler, I will address you. Mr. Kessler, I will like you to stand up.
I will move to address you, Your Honor. Take some remark.
I can defend him all you want. He represents me. He doesn't represent me. You can address him all you want. Hey, I'm the ones that's pushing me.
Your Honor, you made a threat about my...
They support the performance in this manner, statements in this manner.
They support his lawyer to defend himself.
You told me you were his lawyer.
Your Honor,
He is not a lawyer.
The transcript right here.
Your Honor, gone over that.
I told you I fired him before the trial began.
You haven't explained.
I have explained it fully. I have been
No,
discharged.
you haven't, and you will.
I told you on the 26th, and I told you on the 30th.
I tell you, someday you will have to explain it.
That is another threat to the lawyers, Your Honor.
But since it's been said here that all of the defendants, I, over the hour, will reflect the employment of our good risks for bail, and I shall give serious consideration to the termination of their bail if you can't control your client, and you couldn't yesterday afternoon.
I am not a defendant. He is not my lawyer. I want my right to defend myself. I want my right to defend myself.
Your Honor, they said this morning they supported fully his right to defend himself or to have his lawyer of choice. And if that is the price of their bail, then I guess that will have to be the price of their bail.
Now, let me tell you.
I have a right to defend myself. That's what you...
Will you, Mr. Marshall, have that man sit down?
You're saying that there's some misunderstanding about the operation for the right to defend. I have a right to defend myself. I still have a right to defend myself whether you sit me down or not. I still got a right to defend myself. I've got a right to speak out on behalf of my own defense. I have a right to speak out on behalf of my own defense, and you know it. Why don't you recognize my right to defend myself?
May the record show that the defendant Dellinger did the same thing just now.
And I saw it myself.
Your Honor, he is trying to see what is happening.
I want the constitutional right to defend myself. I want the right to cross-examine witnesses. Why don't you recognize the law of this very land? Give me my constitutional right to defend myself.
Beginning of the afternoon on October 20, 1869, court and counsel engaged in a lengthy colloquy during which the following occurred.
Your Honor, I would just like about 2 minutes to respond.
Since he's made all these statements, can I say something to the court?
No, thank you.
Why not?
Because you have a lawyer, and I'm not going to go through all that again.
He is not my lawyer. How come I can't say anything? He has distorted everything, and it's related to the fact that I have a right to defend myself.
Sit down. If there's been any distortion by anybody, I'm perfectly capable of understanding it.
I don't think you will, see? I don't think you will. Your past actions of denying me the constitutional right to defend myself...
Did you want to reply, Mr. Kunstler?
Yes, I did. I want to reply.
I was talking to Mr. Kunstler, if you don't mind.
Then I have nothing further to say, Your Honor.
Bring in the judge.
1982, Title 42 of the Code, where it says a black man cannot be discriminated against in any legal defense in any court in America.
Mr. Seale, do you know what is going to happen to you?
You just got through saying that you observe the law. That law protects my right not to be discriminated against in my legal defense. Why don't you recognize that and let me defend myself? This time when I asked, when I attempted to make an opening statement, you stopped me and denied me that right.
I will not hear you now. I am asking you to be silent.
I want to know, will you? Look, it's a form of racism. Read by stopping my argument is that I was at that point that you recognized that I had the rights to defend myself.
Do you stop or do you want me to direct the marshal?
I want to argue the point about this so that you can get an understanding of the fact that I have a right to defend myself.
We will take him, Mr. Marshal. Take him into the room in there and deal with him as he should be dealt with in this circumstance.
I still want to represent. I want to represent myself.
Mr. Kunstler, will you instruct the defendant, sir, that it is the order of the that they will arise upon the recess?
If that is a direction of the court, I certainly will pass it on.
Oh, none of the defendants have stood at recess to respond to his request. The court will be in recess for a few minutes.
The court will take a brief recess.
The court thereupon ordered the defendant Seale removed from the courtroom, at which time he was forcibly restrained by binding and gagging. The defendant Seale was then returned to the courtroom, but continued to shout through the gag. The court then ordered the marshal to reinforce the gag. The gag was then reinforced, and the defendant Seale was returned to the courtroom. Eventually, the jury was allowed in the courtroom for the afternoon session. To adjust the restraint on the defendant Seale after he had complained of discomfort. Upon the request of Mr. Weinglass and with the agreement of Mr. Schutz, Judge Hoffman ordered the marshal to loosen the elastic bandage which has begun to choke Mr. Seale.
I will excuse you, ladies and gentlemen, with the usual admonition.
The following proceedings were had in open court out of the presence and hearing of the jury.
Your Honor, are we going to stop this medieval torture that is going on in this courtroom? I think this is a disgrace.
This guy is putting his elbow in Bobby's mouth, and it wasn't necessary at all.
This is no longer a court of order, Your Honor. This is a medieval torture chamber. It is a disgrace. They are assaulting the other defendants. Your Honor, this is an unholy disgrace to the law that is going on in there. I'm not saying other than what we have done to this man.
You get down here and watch it.
Somebody going to protect me. Your Honor, may the record show that that is Mr. Dellinger saying Mr. Rubin.
Your Honor, we would like to know to the marshal to show the restoration and explanation of the entire policy. I just said attention to the man. You should be ashamed of your
It's in the courtroom. Session of court is in the afternoon session on Thursday, October 30th, 1969. Following occurred.
I would like to cross-examine this witness.
Ladies and gentlemen of the jury, I will have to excuse you.
My constitutional rights have been violated.
The direct examination is over, and cross-examination is over, and I would like to cross-examine the witness.
All right, sir, I will order you to be quiet.
I want to cross-examine the witness. I want to cross-examine the witness at this time. I object to you not allowing me to cross-examine the witness. You know I have a right to do so.
The jury are excused until tomorrow morning at 10 o'clock. I must order you not to talk with anybody about this case or let anybody speak with you about it. Do not read the newspapers or any other journals. Do not and if anybody attempts to communicate on this case in any manner, please get in touch with the United States who will in turn make a matter for me. Excuse us all at 10 o'clock. Welcome to take the jury out of this case. Now, I want to tell you, Mr. Seale, and I thought you would appear in my direction. You sat there and did not during this afternoon intrude into the proceedings in an improper way.
I never intruded until it was the proper time for me to ask and request and demand that I have a right to defend myself. I have a right to cross-examine the witnesses. I sit through other cross-examinations, and after cross-examinations are over, I requested, demanded my right to cross-examine the witnesses, and my right to defend myself. You cannot sit up here, you cannot sit up here and continue to deny me my constitutional right to defend myself. I sit through our cross-examinations, and I never said anything. I have not struggled with this child, and I have not given my right to defend myself, recognized by you. He is not employed by me. He is not. You know, Sean Gary is my only lawyer, and he's not here. I fired him. Filed an appearance to see me in the jail. Gary,
you said the time is running out. We're going to get a synopsis of the appropriately with your conduct.
I have a right to object. I have a right.
Mr. Marshall, the court will be in recess.
I have a right to my constitutional right.
The court will be in recess tomorrow at 10 o'clock. Item number 16. On Wednesday, November 5th, 1969, during the morning session, following the direct examination of the witness Ray, the following.
I would like to approach the lectern.
You may not
have a right to cross-examine.
You have no right in the circumstances of this case.
Why did you follow me? Could you please tell me, Mr.
The witness is the Deputy Sheriff of San Mateo County in California. He was testified to Seale's perjury of the ticket at the San Francisco airport. Mr. Seale, I ask you to sit down.
Have you ever killed a Black Panther Party member?
Mr. Seale,
have you ever been on any raids in the Black Panther Party office or the Black Panther Party member's home?
Mr. Seale, it's the third time I'm asking you to sit down. As quickly as possible.
Let me cross-examine the witness, man, and defend myself.
You're not entitled to.
This man,
I'm a lawyer of record who signed his appearance in his own
expired. It's not my right before the jury heard one shred of evidence, before one witness had ever raised his hand and sworn at this trial, and that's when the trial started.
You may not stand up.
This man is not my counsel.
You sit down, please.
He is not the representative of me. I am trying to defend myself. I'm not here.
You sit down, sir.
Why don't you see that I have a right to try and cross-examine the witness? I have a right to defend myself.
I am saying that you do not have the right at this particular juncture.
Me, myself, my own person, have no rights to defend myself. This is an erroneous fascist of behind me. How about that, huh? Insulting you. Insulting me. The world and something the people of
Gentlemen, we will recess until 2 o'clock. It appears that Judge Hoffman has now finished citing Seale for contempt. There were 16 counts in all. Accordingly, it is therefore ordered that pursuant to the authority vested in the court by Rule 42A of the Federal Rules of Criminal Procedure and by Title 18, United States Code Section 401, the defendant, Bobby Seale, will be punished for contempt. I will hear from you, Mr. Marshall.
Your Honor, I have already indicated that because I have been discharged, I can say nothing for Mr. Seale. He wants to be his own attorney, as Your Honor has read at least 30 or 40 times from your own opinion. And I think that I would be derelict in my duty to my understanding of my right and liability as an attorney here, were I to speak for him now.
Mr. Seale, you have the right to speak now. I will hear you.
For myself.
You're on behalf, yes.
How am I speaking for?
This is a special occasion.
Wait a minute. Now you're going to attempt to punish me for attempting to speak for myself before. Huh? I mean, now after you punish me, you're going to sit up and say something about you can speak now. What kind of job is that? I mean, I don't understand it. What kind of court is this? Is this a court? You know, it must be a fascist operation like I see it in my mind, you know? I don't understand you.
I am calling on you.
You just read a complete record of my trying to persuade you, trying to show you, demonstrate my rights, demonstrating to you the need, and showing you all this stuff about my rights to defend myself. My rights to defend myself, history, slavery, etc. And sit there and say something about, okay, you can talk now. What am I supposed to talk about? I still haven't got the right to defend myself. I would like to talk about that. I would like to make sure letting me stand up and speak. Can I talk in behalf of, can I defend myself?
You may speak to the matters that I have discussed here today, matters dealing with your contemptuous conduct. The law obligates me to call on you to speak at this time.
About what? About the fact that I want a right to defend myself? That's all I'm speaking about.
About possible punishment for contempt of court.
Punishment? You punish black people all your life. I mean you. They even say that you own a factory that produces raw material to kill people in Vietnam, you know? So it's not, I mean, death is nothing. I mean, if that's what you're talking about, I mean, putting me in jail or in prison or handling and all that stuff, I have nothing to say about that. But I have something to say about the fact that I want to defend myself still. I want my right to be able to stand up and cross-examine witnesses. I want that. So I don't know what you're talking about.
I have tried to make it clear.
All you've made clear to me is that you don't want me, you refuse to let me, I mean, you will not go by my persuasions, my emotions, my request to be, to the extent of even having to shout aloud to get on the record so that they can hear me half the time. You don't want to listen to me. You don't want to let a man stand up and contend to tell you that that man is not my lawyer, show you and point out the fact, in fact, made motions and told you that I fired the man. And to stand up here and say, look, I have a right to defend myself continuously over and over again. Even to the point, just recently, when you recognize that I did have only one lawyer, by letting this man and Thomas Hayden go all the way to talk to Charles Garrett to see about coming out here for me. Which begins to show me that I'm beginning to persuade you to do something. At least allow somebody to investigate my situation. And now what are you talking about? I mean, now all of a sudden on the record.
I don't make that clear. I don't question any further. The law gives you the right to speak out now in respect to possible punishment for contempt of court, sir.
Well, the first thing, I'm not in contempt of no court. I know that. I know that as a person and as a human being, I have the rights to stand up in a court and use his constitutional rights to speak in behalf of his constitutional rights. And that's very clear, I hope. That's all I have to say. I still want to cross-examine the witnesses. I make those requests, I make my motions, and I make those requests. And I will continue to make those requests, hoping that once, in one way along this trial, you will recognize my rights as a human being, as a black man living under the scope and influence of a decadent America, where the government of the United States does not respect black man's rights, and have never recognized them since 1867, to the Dred Scott case situation. In a period of slaves, you have never recognized them, and here you are now. And all I can say is that you're probably acting in the same manner as Benjamin Franklin and George Washington. And we're after that kind of business.
Oh, but you are mistaken about that.
Yes, you're acting in the same manner as those courts acted in those periods of slavery history, and you know it. That's what you're doing. You know, if a black man stands up and speaks, if a black man asks for his rights, if a black man demands his rights, if a black man requests his rights, what do? You start talking about punishment. If a black man gets up and speaks on behalf of the world...
Are you addressing me, sir?
I'm talking, and you see I'm talking.
That's right, but if you address me, you're going to have to stand.
Stand? Oh, stand now. Now let's see. First you said I couldn't stand. Well, I've got a suit, and I'm going to a higher court, possibly to the highest court in America.
In conformity with the provisions of Rule 42A of the Federal Rules of Criminal Procedure, I shall certify that the series of criminal contempts committed as described by the court in its oral observations and specifications 1, 2, and including 16 were committed in actual presence of the court. Seen or heard by the court during the trial of the case of the United States of America versus David T. Dellinger and others, 69 CR 180. I find that the acts, statements, and conduct of the defendant, Bobby Seale, constituted a deliberate and a willful attack upon the administration of justice, an attempt to sabotage the functioning of the federal judiciary unit, and a misconduct of so grave a character as to make the mere imposition of a fine and futile gesture and a wholly insignificant punishment. And accordingly, I judge Bobby G. Seale guilty of each and every specification referred to in my oral observations. And the court will strike that. And the defendant Seale will be committed to the custody of the Attorney General of the United States or his authorized representative for imprisonment for a term of 3 months on each and every specification, the sentences to run consecutively. I direct the United States Attorney to prepare from the oral remarks I made here a certificate of contempt for my signature to with judgment and commitment orders. How soon? You'll have to get the reporter to have that written up for you. How soon, Mr. Reporter, will it be before it's written? Glad I've got both of you here today.
6 o'clock.
Well, get it to Mr. Ferran as soon as you can, and then I'll ask Mr. Ferran to get the certificate to me, and the case will be continued until tomorrow morning. There will be, in view of the disposition of this aspect of the case, there will be an order declaring a mistrial as to the defendant, Bobby G. Seale, and not as to any other defendant.
Wait a minute. I've got a right. What's this cat trying to pull, huh? I mean, now I'm leaving. I can't stay.
The court will be continued until tomorrow morning at 10 o'clock for signing the certificate of contempt. Continue with the trial in respect to the other 7 defendants.
Everyone, please rise. If the court please, we have the jury before.
Oh, yes. I'm glad you reminded me.
Will Your Honor set a trial date for the defendant Seale?
Yes.
I demand an immediate trial right now.
Sit down, please. Under order.
I demand an immediate trial right now.
We'll give you a trial date.
Now, I want to take it out. I have a right to go through this trial.
A mistrial has been declared with respect to you, sir. Your trial will be conducted on April 23, 1970 at 10 o'clock in the morning.
I want an immediate trial right now, though.
I'm sorry, you can't try 2 cases at one time. Ladies and gentlemen of the jury, I deeply regret having to keep you confined in the jury room this long, but there were matters the court had to consider with the parties and the counsel out of your presence. Since it is now nearly 4:15, we'll be in recess until 10 o'clock tomorrow morning. The usual orders not to talk with anybody about this case or let anybody speak with you about it. Do not discuss the case among yourselves. Do not read the newspapers or any other journals. Do not listen to radio or television or look at television. If anybody attempts to speak about this case, please communicate with the United States Marshal, who will in turn lay the matter before me. Mr. Marshal, the court will be in recess until 10 o'clock tomorrow morning.
Everyone will please rise.
I still want an immediate trial. You can't call this a mistrial. I'm being put in jail for 4 years for nothing. I want
You
There's a lot to unpack there. Thank you.
David, are you guys gonna take some questions, or?
We'd be happy to, you know, or any
Comments? Comments, questions, protests, motions?
Could you speak at all on the history of the recording? Because this was like created.
Yeah.
This is not like a document of the actual cut.
Well, it's a reenactment, theatrical reenactment that comes right from the transcripts. Mm-hmm. So I'm trying to think of the year. Typically, a couple times a year, I've been interested in a lot of working with vinyl in different ways. And spoken word has been, you know, occasionally stop into Cheapo, and they've got a pretty decent and interesting collection. And so I just bumped into this over the summer, and I thought, oh, it's interesting. There's not a lot of information given, and I wasn't able to really go in and, you know, and look at the details. It's a dramatic historical reenactment. It is quite faithful to the, if you get the tales of Hoffman and follow it through. That particular date of November 5th was when all of the various charges, contempt charges, were dealt with. Sertron Corporation Musical Division presents this recording as an enhancement to realism in reporting the details of that portion of the official transcript of the trial of Chicago 7 as it relates to Bobby Seale. And this is another paragraph. I'll go ahead and read. The trial and the circumstances surrounding the trial of a national controversial nature and therefore of public interest. We feel that the subject matter is one that will appeal to the general public for information and study purposes. However, it may relate to the individual who listens. So it's more archival and I would say kind of scholarly rather than any kind of commercial. There's not a lot on the vinyl itself.
Listen just to how many times he says the same thing over and over and over and over and over again, and the machine just grinds him up into pulp and then spits it out. You know, it's just,
just shows that nobody's listening.
Well, it's interesting that you say that because while aesthetically I really appreciated this performance, thematically I had somewhat of an issue dealing with the abstraction and destruction of a person of color's voice by three white identified
I think there's a whole set of problematizing issues that no doubt come about, you know, from that sort of setting and the idea of even undertaking it as a project.
I think at the end you heard his voice much more clearly,
for sure.
And that was part of the construct that I think we did tonight. I think that we were the machine to a certain extent, and it is problematized, as David, I don't know if that's a word, but if it is, I'm going to use it. It's a complex issue, And if you're adding music to any text, you have to figure out what the relation is between what noise you're putting in front of the narration and what you let when you let the narration through.
Yeah.
And I think at the end, you heard repeated over and over again, you know, what he was trying to say and couldn't be heard. And at the end, just before the mistrial, you go, okay.
There's really two main things as I listened to it and before bringing these other two folks in. It's the two things that struck my ear mostly were one, the fact that he simply was pleading to be able to represent himself, and then all of that business about his lawyer and the court insisting that, well, Kunstler's a lawyer, he's, you know, so therefore you have the lawyer, and so there's this constant issue back and forth. And then the right for him to cross-examine the two or three witnesses. I mean, there's not a huge, there might have been a sheriff's deputy, and he says, you know, you ever kill any Black Panthers? And he had two or three questions, and that was about it. That's all he was to say. The voice as a sound form and getting in and messing with it. I mean, that's loaded with issues, and I think rather than try to set a strategy up for how to deal with that, the idea of using the record as an instrument, along with two other instruments, and simply dealing with a kind of free improv of sounds, allowing bits and pieces of meaning to kind of ooze out as the texture builds and recedes. I think primarily we were taking a kind of musical improvisatory aesthetic approach with that, and the listening for the profound points of, oh yeah, and they're different each time.
The ending, those low notes, you wouldn't know, but that was a phrase called "you must obey," and it was, in my mind, I used that because I wanted, this was my personal comment to myself, that the whole machine was broken, so you couldn't actually hear what it said. And I think the whole trial was broken.
Yeah, I mean, obviously.
It was, the machine was grinding away. He himself ended up in prison. But the whole message of this, I think, speaks that even the institutions that are supposed to protect individuals can be broken and used badly.
So then, in a way, could you view this ensemble and performance as the institution?
Yes.
In a way.
It is.
In a way. There was a place where he was really losing it and getting very angry, and I felt like I was supporting that with the pizzicato thing. That there is, I think what you're asking is, how can three white dudes have a response to Bobby Seale?
No, not necessarily. I understand that. I'm saying, how can three white dudes take a person of color's voice and destroy it even more, and destroy that message
and
even
interpret
more.
what his words are trying to express. And I think that is problematic. You have to approach it with some respect, great deal of respect, but also recognizing that his words have to be true. Yeah.
And I think, I agree that it has to be given with respect. But I think my whole feeling throughout this whole evening has been one of suffocation and one of being underwater. And so I couldn't help but put myself in Mr. Seale's position. And I think that that was the overarching attitude of your work. And for that, I think you're very successful.
I felt personally, in terms of working with touchpads, the idea of a court stenographer, not that we're trying to do a theater piece or anything per se, but essentially, if anything, I thought of myself in that role, but the more I started to work with materials, I thought about discovering points of handling the material that gave some dignity to what was being said, and also other points of covering up and destroying some of the parts of the text that would come from the judge. But it was very difficult to, to rehearse that out, and really I didn't have any interest in trying to do that. I'm not sure I could, or that the piece would have been as spontaneous or essentially as musical. And I mean, we're essentially three composer performers, but we're also each responding to those particular events. And I think my own peculiar interest in it being 50 years ago, in terms of, like Peter's comment, historically, those kinds of dates are important. But it was also one of a number of things that happened between June of 1969 and 1970, when I was in fact not in this country. And I was serving in Vietnam, not by my choice, with other men who were there, who are also drafted and not at all interested in that kind of American foreign policy, if you will, and many of whom were from Chicago and the inner city, were very familiar with Mark Clark and, just all the kinds of politics that were going on at that moment. There was a whole thing in a lot of the infantry units in Vietnam where there were at least half to sometimes upwards of 70 to 80% of the a typical platoon would be draftees, and of those draftees, a clear majority were, if not outright anti-war, did not really think of themselves as warriors in that sort of militaristic sense.
But in the machine. Against
part of the machine. So, like a lot of things, political and historical, they're complex in the moment, and 50 years later, they're maybe even more controversial and complex.
I suspect that several in this room remember living through this and knowing about it. I was in Madison, Wisconsin, and there was intense demonstrations and National Guard and all that sort of stuff going on. What was going on in Chicago was strongly felt, and everybody, I think we can now say, in retrospect, there was this huge machine that was running, and people were trying to fight against it, and there was a lot of personal destruction that happened in that process, and also transformation, actually. I can speak for myself. I came from Wyoming, which is one of the most conservative states in the Union. And that I had a very conservative attitude about stuff. And my time in Madison and the demonstrations and the controversy flipped me totally. And from my perspective, I grew because other people protested and I was able to see their, and see what happened to them in case of Bobby Seale, and how the machine was. I would have said, you know, before I came here, well, you know, we got the law. After I left Madison, well, screw the law. So.
But you said 50 years since you were. Do you think you figured it out since then?
No.
Have you had any answers that you figured out?
I get deeper into it. I'm in the middle of a short-term residency at the Center for Performing Arts, and that's very much focused on my personal experience as an infantry radioman, and I'm working with another dance musician, and I'm working in a space with sounds, and although I'm not a trained dancer, I'm probably 80% of what I'm doing is movement based, and that's exciting because there's things in that are unlocking emotions that I think the only thing that comes closest to it is this idea of free improvisation through music, which I've been very privileged to be able to do with these folks and others. But putting a kind of narrative line to that in a more traditional way through writing and plays and theatricality is difficult for me to navigate, I think, as an artist. But I am interested in sort of pushing myself into these areas and continuing to look for and discover things that I've kind of conveniently compartmentalized, avoided, formalized, and whatnot. And I think, you know, with the decades come a sense of, well, you know, I think I have enough in my life that I can get a little closer to those kinds of things and not feel quite as vulnerable. And if I approach it humbly with the idea that I don't know, you know, where it leads or what it adds up to or means, you know, in that sort of largest context, I guess.
I really appreciate the insights you all have in asking the questions and to hear your observations, what you felt about this. This is maybe the purpose of art, maybe.
This is just a great venue, also. Thank you, Peter.
Thanks, Peter.
This is the third time I've played over here, and of course, the acoustics and all of that, but it's the audience, spirit, the audience, the community, and this conversation.
I hesitate to take the conversation away from the personal because I think this has really been important for us, particularly of the generation that lived through it.
Of a certain age.
But,
yeah.
right, I want to just make a point about the space that Tony Luau over here has been working with us, and he's created this book display in the back of books that we have about the Black Panthers, and I would encourage you to take a look at them before you go and know the kinds of resources that are here. But I also want to just, for a moment, go to the more social level. And on a week ago, or last Saturday, we had two people here, Elaine Tyler May, who teaches at the U, and Scott Laterman, who teaches at UMD, talking about books that they had recently written. And Scott's book is, in fact, a book about Nixon's use of the term silent majority. And listening to Bobby Seale tonight and the times that he used the word fascism, it's hard for me to figure out, are we in the same place that we were in 50 years ago? What mattered that happened in between? Is there a way that we're not in the same place that we were? Because some of us use the word fascism to describe what's going on and not, but in a lot of the rest of the world today. And I don't have an answer for that, but I think that it's a really interesting, I find it an interesting question. And was there progress for a while and then we got pushed back, or has the machine always been there? I should add, last night, Marty Case was here talking about the history of treaties, and he pointed out that in 1778, 2 years into the American Revolution, the new government began to pay soldiers by giving them land, which didn't belong to them, and that and the higher you were in the hierarchy in the military, the more land. Yeah, and there were people given 1 million acres of land, and which they wouldn't know what to do with any more than the CEOs of contemporary corporations know how to spend the billions of dollars that are piling up in their bank accounts. So, it makes it, the machine always been there, and everything else has just been kind of, smoke and surface. Yeah. Well, and it's terrible to say I don't have answers to those questions.
You have to have the right questions.
Are they the right questions, Aaron?
Some of the right.
Some of them, yeah.
I think there was a period in my sense from about 74. I was in grad school working in public radio as a student. When Nick saw the whole Watergate thing was very, very close to the surface there. In 1974, after Nixon resigned, he would have been impeached. There seemed to be a period, and maybe it was just a period in my life when things were connecting in ways, but I would say from 74 to the Iranian takeover of the embassy in Tehran, which was what, 79?
Yeah.
I mean, this is when Saturday Night Live came on in its first few seasons, and it was like, oh, well, this is sort of interesting on, television. It's like things did seem to get maybe a little better. There were a lot of grants for artists and poets and this and that, and so at some level there was a kind of an optimism, but it didn't take long for the machine, or however you want to talk about that kind of bureaucratic inertia.
I think that the founding of the United States was idealistic, and thank goodness there was a try. But I think what happens all the time is people can be corrupt. And so there's corruption happening all the time. So it's a constant fight for justice, for fairness, for looking after the environment, all of those things. If you don't do that, it goes away. All those things go away. And you're back into fascism and destruction. So I think the court in this case, and Bobby Seale, is sort of a microcosm of that problem. And so it kind of was interesting to me to go back, because I hadn't entertained this idea of Bobby Seale for a very long time. So,
thanks, David.
Yeah. He's still with us. He's
oh yeah,
he lives in California.
Yes.
I think there's times that we have, or cycles that we have that are optimistic and progressing. Let's not take a label on it, but we're progressing. And other times people react to that progression and pull back. And that's been going on as well, as long as there have been people. So I think we're really noticing, because we have a particularly effective communicator in the White House, we're noticing much more, it's easier to diagnose the problem. I do think there's reason for hope. I don't think there's any reason to, many of my friends, and I'm very active on Facebook, and we have a constant conversation about what's going on. And many of them are defeated, exhausted, resigned. And I think that's wrong. We can't do that. And it's not about resisting the resistors, you have to find what energy you have to do what you can do to make it better. I think that's what art, making things in general. You talked about, did we talk about this?
Yeah,
creating is the way to move forward. And constantly being bombarded by what's being produced by others is not healthy. So I encourage all of you to make something.
Bring it here. Make something, bring it here.
We need better metaphors too. I mean, the idea that a pendulum is politically swings one way and it swings out. I mean, that held out for most of our lifetimes, but in the digital world, it's a 0 or a 1, and there's nothing in between. It's a pop without the snap, crackle, or Kellogg endorsed. I mean, there's Frank Kellogg.
That was an industrial age metaphor. Now we're into a different metaphor.
Well, exactly. And so, poets help us, and artists to give us some new models, some new metaphors.
Well, let's give them another. Look at the books. Make sure you sign the guest books.
Oh, yes.
Yeah.